nominated him as his vice presidential candidate on the 14th July 2022. In other words, that at the time before the respondent was nominated, he had accepted nomination as the vice presidential candidate of the second respondent. He was still a validly nominated central candidate of the second respondent for Borno Central District. The petitioner then contended that the second respondent had earlier submitted the name of the third respondent together with that of the fifth respondent to annex as his presidential and vice presidential candidates for the 25th February 2023 election. However, that before the date of the election, the fifth respondent withdrew his candidature as the running mate of the third respondent on the 24th June 2023, and the name of the fourth respondent was then submitted to annex, that fifth respondent, on the 15th July 2022. That the second respondent did not conduct any fresh primary election for the purpose of picking another running mate for the third respondent after the withdrawal of the fifth respondent. The respondents conceded that the fourth respondent was ab initio the central candidate of second respondent for Borno Central District. However, that on the 6th July 2022, the fourth respondent, via a letter dated the same date, notified his political party, that second respondent, of his withdrawal from the central candidature. That upon receipt of the fourth respondent letter, the second respondent immediately notified ANEC, and which notification letter was received on the 13th July 2022. That the same letter also notified the first respondent of his intention to conduct a fresh primary election for the replacement of the first respondent following his withdrawal as a central candidate. That it was until 14th July 2022 that the first respondent was nominated as the third respondent associate for the presidential election of 25th February 2023. The fifth respondent notice of withdrawal as a candidate is in evidence as Exhibit PA2, while the notice of withdrawal and letter of voluntary withdrawal of the fourth respondent are in evidence as Exhibits PA3 and PA4 respectively. It will appear that the petitioner is the view that the fourth respondent was still the central candidate of the second respondent as at the 14th of July 2022, when the fourth respondent was nominated as the vice presidential candidate of the second respondent. However, the respondents contended that the issue of alleged double nomination of the fourth respondent has been determined finally by the Supreme Court in People's Democratic Party, PDP versus ANEC, that in the circumstances, the said judgment of the Supreme Court constitutes estoppel parem judicata and binding on the parties in this petition. Now, for a judgment to constitute issue estoppel, the conditions I had earlier stated in the rulings. So the three elements must be present and coexist for a plea of estoppel parem judicata to apply. In the cases of Ito and Epe and others, Oshoboja versus Amida and others, and Alexandra and others versus Lone Star Drilling Company Limited, all citation supply. It is obvious that the judgment sought to be relied on for the plea of estoppel is that of the Supreme Court, the highest and final court in this country. There is no doubt that the decision was final, and the issue that was determined by the Supreme Court is the same as in the present petition, with whether the fourth respondent breached Section 35 of the Electoral Act but by allowing himself to be nominated in more than one constituency. The petitioner has, however, argued that the issue decided by the Supreme Court was merely on the local standing of the PDP to question the nomination of the fourth respondent, a candidate of the APC, a different political party. That may well be so, but it is clear from the judgment, thus Exhibit X1, that the Supreme Court pronounced on the substantive issue of double nomination. Though Joro JSC, who delivered the lead judgment, declined to exercise the powers of the Supreme Court under Section 22 of the Supreme Court Act to pronounce on the merit of the case, the other laws of the Supreme Court proceeded to do so. It is settled law that a contributory or concurrent judgment has equal weight as the lead judgment. It is part of the lead judgment and therefore has the same force and binding effect. The mere fact that a concurring or contributed judgment contains what is not in the lead judgment will not whittle down its binding effect. Thus, in Olu Fiagba and others versus Abdurrahim, my Lord Fabi JSC said, quote, the concurrent judgment has equal weight with or as a lead judgment. A concurrent judgment complements edifies, and adds to the lead judgment when the justice adds its certain fact aspects which the writer of the lead judgment did not remember to deal with. Insofar as the concurrent judgment performs same for all the above functions, it has equal force with or as the lead judgment insofar as the principles of stare decisis are concerned. Now, it is apparent that the parties in Exhibit X1, PDP and ANIC, and other supra are not the same as in the present petition. The earlier decision, though, involved the first, second, and fourth respondents. The present petitioner was not a party in that case. That is why it was argued by the petitioner herein that Exhibit X1 cannot operate as to stop it from litigating the issue of dominant nomination of the fourth respondent. The respondents have responded that the judgment in PDP and Annex Exhibit X1 is a judgment in rem as opposed to judgment in personam. In law, a judgment in personam is a judgment against persons who are parties or privy to the particular suit or proceeding alone. It is referred to as judgment inter partes. It is a judgment binding on the parties to the action alone. A judgment in rem, on the other hand, is a judgment that determines the status of a person or thing as distinct from the particular interest of a party to the litigation. It is referred to as judgment contra mundum, binding on the whole world. It is therefore binding not only on the parties to the dispute, but even non-parties. Therefore, once the status of a person or thing has been pronounced upon by a court of competent jurisdiction, no person is permitted to assert the contrary of what the court has decided. See Black's Law Dictionary, 11th edition at page 1008, Demishola versus Bolarinwa, Giannati Petrochemical Limited and EFCC, then Ladi Jobi and others versus Oguntayo and others, Petition Supply. It is no doubt that the judgment matter in PDP and INIC others X1 was in respect of the alleged double nomination of the first respondent as the vice president candidate of the second respondent in the 25th February 2023 presidential election. That is the same issue raised in this petition as grounding the disqualification of the third and fourth respondent in this petition. Pronouncing on this issue in this case, in the contradictory judgment, my Lord Okoro JSC, who presided on the panel of the Supreme Court, held as follows, I quote, "There is no doubt that the fourth respondent was at a stage nominated as a candidate representing Borno Central District, but upon being muted, he would pair with the third respondent as vice presidential candidate of second respondent, All Progressive Congress, APC, in the 26th February 2023 general election. He withdrew his candidature for the Senate before taking up the position of vice presidential candidate. Documents in the record attest to this fact. These are APC 1, APC 2, which were made on the 6th and 10th of July 2022, respectively, laws of court. After considering those documents, His Lordship concluded at page 7 of the contrary judgment that, quote, "It is crystal clear that the two exhibits alluded to above, the fourth respondent did the needful by resigning his position of Senate candidate for Borno Central District since 6 July 2022, before being nominated by the third respondent to run alongside him as vice presidential candidate of All Progressive Congress," close quote. My Lord Okoro went on to, after citing section 31 of the Electoral Act 2022, held at page 8 of his contributory judgment that I quote, "The above provision of the Electoral Act 2022 was duly complied with by the respondent. My well-considered opinion that as at the 6th of July 2022, having withdrawn his nomination and personally served him on the second respondent of the withdrawal of nomination of on 6 July 2022, the fourth respondent was no longer a candidate for the Borno Central District elections, and his subsequent nomination as vice presidential candidate of the second respondent for the presidential election was not multiple nomination, as there was no longer a nomination for the fourth respondent since his withdrawal on the 6th of July 2022. I have also cited the elaborate contribution of His Lordship, Ajim JSC. So I have endeavored to quote extensively the dicta of the laws of the Supreme Court in PDP and INIC Supra in order to show that the issue of double or even multiple nomination of the fourth respondent as the central candidate and vice presidential candidate of second respondent in the 25th February 2023 general election has been settled to finality. It is a judgment in rem, therefore binding on the parties to this petition and in fact the entire world, including this court. Being the judgment of the final court of the land, of this land, this Supreme Court, no person is permitted to again raise and litigate on it in any other action or proceeding. It is therefore settled and remains settled that this petition, which questions the qualifications and seeks to disqualify the third and fourth respondents from contesting and occupying the seat of President and Vice President of Nigeria on ground of double or multiple nomination of the first respondent and Vice President candidate of the second respondent on ground of double or multiple nomination of fourth respondent has no substance. I only wish to add that Section 35 of the Electoral Act is targeted at the candidate and not the political party. That is why it uses the terms a candidate and knowingly allows himself to be nominated by more than one political party or more than one constituency. That's to prove that a candidate knowingly allows himself to be so nominated. Both the intent and actual acts of nomination, that is, the mens rea and actus reus of the act prohibited, must be proved, the stipulation in the section being a penal provision. In the instant case, neither the intent nor the fact of the first respondent to allow himself to be so nominated was established. That's why His Lordship Ogumi JSC, in his contributory judgment in Exhibit X1, held as follows, I quote, by Section 31 of the Electoral Act, the fourth respondent, Shetima, was obliged to submit a notice of withdrawal in writing to his party, which he did, and then his party is to deliver that notice to the Commission not later than 90 days to the election. In view of the above stated position of the law on this issue and the facts of this case, there exists no animus or display of intention by the fourth respondent to stand as the nominated candidate of the second respondent for the vice presidential position and also the senator representing Borno Central District in the general election of 25th February 2023. There cannot be any other interpretation in the circumstances unless there is clear intention to knowingly stand as a candidate for two elective posts in the same election cycle. Jim JSC also contributed as follows, quote, the manifest intention to relinquish the earlier nomination to pave way for the nomination of another person to replace him as the party's central candidate cannot be overlooked or disregarded. To simply isolate the assumed or purported short-lived coexistence of the two nominations for treatment as multiple nomination without regard to the obvious intention of the first respondent not to be the party's candidate in elections in two constituencies is against the legislative intent of Section 35 of the Electoral Act 2022. The sequence of the occurrence of the events is not what determines the existence of multiple nomination. It is the intention, design, or purpose to hold two or more nominations as candidate for election that shows that the person so nominated knowingly did so. Second respondent did not intend that the first respondent should be its candidate for Borno Central election and its vice presidential candidate for the presidential election. The first respondent did not understand or know that he was so nominated. The word knowingly in Section 35 of the Electoral Act must be interpreted broadly to include all its literal meanings. Barton's Legal Thesaurus, fourth edition by William C. Barton at page 356, is defined to include advisedly, deliberately, designedly, intentionally, learnedly, pointedly, purposefully, with knowledge, etc. It is clear to me, therefore, that from the oral and documentary evidence adduced by the parties on this petition, the intention and fact of knowingly allowing himself to be nominated in more than one constituency as alleged by the petitioner against the first respondent has not been established. In other words, both the mens rea and actus reus of the act prohibited by Section 35 of the Electoral Act 2020 were not established. One other aspect alleged by the petitioner on its claim of invalid nomination of the third and fourth respondent is that the second respondent did not comply with Section 33 of the Electoral Act in the nomination of the first respondent as vice presidential candidate. That after the withdrawal of the fifth respondent, the second respondent should have conducted a fresh primary election within 14 days for the purpose of nominating a new vice presidential candidate. Now, Section 33 of the Electoral Act stipulates that a political party shall not be allowed to change or substitute its candidate whose name has been submitted under Section 29 of this Act, except in the case of death or withdrawal by a candidate, provided that in the case of such withdrawal or death of a candidate, the political party affected shall, within 14 days of the occurrence of the event, hold a fresh primary election to produce and submit a fresh candidate to the Commission for the election concerned. The interpretation of this provision does not, in my view, cause any difficulty as to require the application of any technical rule of construction. Therefore, a literal interpretation will suffice. It therefore means that where a political party has submitted the name of a candidate pursuant to Section 29 of the Electoral Act Supra, it cannot be allowed to substitute or change that candidate except in the event of death or withdrawal of such candidate. By the proviso thereto, the political party affected is enjoined to conduct a fresh primary election for the purpose of producing a new or fresh candidate to submit to the Electoral Commission. The grounds of the petitioner here is that the fifth respondent withdrew his nomination as vice presidential candidate of the second respondent, but the second respondent did not conduct another primary election for the purpose of producing a new vice presidential candidate within the 14 days prescribed by Section 33 of the Electoral Act. It should be remembered that by Section 142, subsection 1 of the 1999 Constitution, a presidential candidate for election to the office of president has the sole discretion, authority, or power of nominating his associate who shall run with him in the election as vice president. The choice or nomination of vice presidential candidate is not the product of any primary election. Therefore,
okay, my people, we are back again. This is not a breakdown of the update from the courts on Shettima double stroke multiple nomination. 1. Shettima cannot be disqualified as earlier stated by the court as the basis of argument is not on the 1999 Constitution. Number 2. Every disqualification must be based on those provided for under Section 137 of the Constitution. Then another one is the court just held that the Supreme Court decision where PDP questioned Shettima's double nomination was substantial and final and binding on all the parties and the entire world. Since it is Supreme Court judgment, it stands. The court upheld the arguments of Tinubu stroke APC. Please note that the court is still on the APM case. Let's go back to the court.
Between the period the fifth respondent expressed his intention to withdraw and his actual withdrawal or purported nomination, thereby invalidating the nomination of third respondent because the candidature of the third respondent had lapsed and was no.
Another breakdown here, the court holds that Shettima has no intent to be a multiple candidate by his conduct of sending the withdrawal letter to the party. Let's go back to the court, my people.
Nominate his associate, who shall be his running mate for the office of president. There is also nothing that invalidates the nomination of a new associate by a presidential candidate as his running mate after the withdrawal of a previous associate, so long as the nomination of the new associate was submitted to the first respondent 90 days before the election as mandated by Section 31 of the Electoral Act 2022. This contention of the petitioner is therefore discountenanced. It is therefore my view that, that the position of a person as vice presidential candidate not being subject to primary election, the provision of Section 33 of the Electoral Act 2022 would not apply. On that note, I hereby hold that the petitioner failed to prove the lone ground of his petition to the effect that the third and fourth respondents were not qualified to contest the election held on 25th February 2023 for the reason of double nomination. Having resolved the sole issue of this petition against the petitioner, this petition is held to be devoid of any merit. we'll rise for just 15 minutes and continue with petition number 3 and 5. I can see Dr. Levy moving up and down. So, as an elderly person, I know what is going on.
My Lord, we're just wondering, sir. We just wondering, my Lord, if your brethren agree with your judgments or not.
Pardon?
I said, we're just wondering.
No, it's a consolidated judgment. They will give their contributions after we have read all the judgments.
Oh, my Lord, yes. Please. We just needed to know, sir.
Yes, they will give their.
Thank you very much, my Lord. Thank you, sir.
Call the court.
Well, so far.
The first part. Well, we can't tell at this time if it's the first part, but first part of the proceedings has just gone underway.
Well, what the...
Good day, my well-meaning Nigerians and fellow obedients worldwide. Welcome to Hope Alive. So, today, we all know is a D-Day for the PEPT judgment, hearing, and there are 3 people that filed a case: APM case, the LP case, and the PDP case. But for now in the courts, they are handling the APM case. So this is the updates from the beginning of the court till now, in no particular order. Updates at the Presidential Election Petition Tribunal today, Wednesday, 6 September, Judgment Day. The courts have struck out some paragraphs 4, 5, 14, 15, and many others of the petitioner's reply to the respondents have been struck out for introducing new facts. The court is attending to several applications which were made before the court. The one above are applications made by the respondents to strike out some paragraphs of the petitioner's reply, not the petition proper. The court has ruled that 1. Qualifications of a candidate can only be contested under Section 131 and 137 of the Constitution. 2. Tinubu and Shettima cannot be disqualified on the basis of double/multiple nomination or even sponsorship. 3. P2B attempt to use 142 bracket 1 of the Constitution as a basis will not be upheld by the court. 4. The issue of double/multiple nomination should have been ventilated in the Federal High Court. The court holds that the application have no merit and is struck out for being incompetent. The court have struck out 2 grounds of objection by the respondents against the petition. They have argued that the petition was filed out of time and is packing in merit. They also argued that since the petitioners had instituted an action in the High Court, which were thrown by the doctrine of estoppel, the petition should be thrown out. The court held that it was a different suit and the former was a pre-selection matter, while this is post-election. The court has held that the petitioners have no local standing to question issues of nomination, as it is a pre-election matter. It further held that anybody who is not a member of a political party must look numb and be an onlooker, as he does not have local standing. The courts have struck out the grounds for being incompetent, as it is purely a pre-election matter and internal party affairs. The courts have discountenanced the motion of the petitioners for not joining other parties, PDP. The court held that a candidate or political party can institute an action. Hence, it is okay if they decide to include that party or not. He further held that joining them is just to make them bound by the judgment. The court now proceeds to the main petition. As it stands, the APM have no case anymore, as their issue for disqualification was solely tied to provisions, the Electoral Act, and not section 137 of the 1999 Constitution. On Shettima double/multiple nomination, 1. Shettima cannot be disqualified as earlier stated by the court, as the basis of argument is not on the 1999 Constitution. 2. Every disqualification must be based on those provided for under section 137 of the Constitution. The court just held that the Supreme Court decision where PDP questioned Shettima's double nomination was substantial and final and binding on all the parties and the entire world. Since it is the Supreme Court judgment, it stands. The court upheld the argument of the Tinubu/APC. Please note that the court is still on the APM case. The court holds that Shettima had no intent to be a multiple candidate by his conduct of sending the withdrawal letter to the party. The court has struck out the petition of APM, and as it is devoid of any merit, having resolved the issues on double/multiple of Shettima in the favor of the respondents. The court will now rise and continue with P2B petition shortly. So these are the breakdowns of the case from the beginning of the courts till the end. And in a very short time, our legal analyst, UC Maxwell, will join us live on Zoom to be able to explain and dissect all these things one after the other. So stay tuned to that time. In the meantime, like, share, subscribe, and tell your neighbor, tell everybody to come on, because this is the day we are looking forward to. This is the D-Day. This day will make or mar this country. And we are looking forward and hoping that the judiciary will do the right thing, and do the right thing they shall today. So don't leave, stay glued as we look forward to the next thing. Esther, if you have anything to say.
Okay, my people, don't see them now. Well, a very big shout out to our legal counsel team led by Sam Viko, and all the lawyers in courts. We want to say a very big shout out to you guys. We appreciate all your efforts. And we know that today, at the end of the day, we are going to rejoice and celebrate for a new and a better Nigeria we are hoping for. It's coming. So this is the right time for the country, for Nigeria to be free from the hands of selfish and criminal politicians. My people, a new Nigeria is very, very possible. Let's keep our hope alive.
Yes. Yes, and if you hear everything that's going on in the court, it seems as if these people are trying to, derail from this thing. But let's just hope that as they are done with APM case, after the court recession, the 15 minutes break they have, and they come back, we'll enter into P2B's case proper, and we'll actually listen and hear everything they have to say. Because if they actually play kuru now, we'll see it firsthand that these people are trying to play with us in this country. And this country is not a playground. It's not. The law is not a chessboard that they are using to play. It's not for politicians to be playing around with. They should uphold the law and uphold the cause that they should be opening in the country. They should not play with us here. So we are waiting for the 15 minutes break to pass, and then we'll come back on live to be able to see what is going on right in court. So in the meantime, let me read some of the comments that I'm seeing here, because some people have been commenting. It's been vexing some people, and I understand. I feel your pain. I feel your pain. It's in the pain everybody for everywhere, every part of the country. A lot of people have been watching us live, and they have been commenting. Okay. Okay. Some people are saying that I believe in our judiciary and we hope that they will do the right thing. Nigeria judges are inviting anarchy in Nigeria. If they do the wrong thing, that is literally what they are saying. That is literally what it means. But we hope they don't do the wrong thing. We hope and pray that they actually do the right thing. Because the way that person that is reading those things in the court, he is stammering like he is not the one that wrote it. He's stammering like he's not confident with what he wrote. Because if they actually wrote the right thing, I don't know why he's jittering and as if he's scared of saying what is written there for him to say. But let's be looking at them, Sha. Someone said, can APC battle with the Lord Jesus Christ? My answer is no. Yes, even God is looking at us in this country and he will help us to save this country. Yes, he has to help us. Someone said, hope Nigeria won't fail us. No, we hope Nigeria won't fail us. We are hoping that Nigeria won't fail us. And who are the people that are going to save the country? It is the judiciary, because it is in their hands right now to either uphold this country or bring us down to the ground. Someone now said, in 1999 constitution should be scrapped if the PEPT judgment doesn't uphold the supreme law. Emergency should be declared in the contrary. Tinubu will not be disqualified. The judge will say the certificate forgery and forfeiture cases took place over 10 years ago. We hope that doesn't happen, though. We hope that doesn't happen. But as we go on, our legal analyst will join us very soon to be able to analyze all these things. So stay tuned and don't go anywhere. They will analyze all these things, break them down one after the other for a layman to understand everything going on in the court. Because I know that some people will be shouting that it's big grammar, then they speak there. Let somebody break it down. Just hold on a minute. In no time, they will join us. Okay. Someone said, the judge is compromised and invokes on anarchy because of injustice. Like I said before, that's what we are hoping. We hope they don't bring anarchy to this country because we are not ready for that. This country is not ready for a coup. They themselves, they are not ready for a coup. So if they know the right thing they will do, if they know something that when they finish giving out this judgment, the country will be proud of them, their children will be proud of them, you know, their families will be proud of them. In 50 years' time, if they hear what's going on, they'll be proud of themselves that they made such a decision. That is all we are asking from the judiciary. If they made anything that is contrary to this, they should better take the 15 minutes break now and reconsider and rewrite, because I don't know. They should better make the right decision for this country. That is all we are saying. Esther B.
Of course. The right time is now. All this time we've been shouting, all eyes on the judiciary, all eyes on the judiciary. The time is now. Today is the judgment day. The time to give us the right judgment. The judiciary should do the needful. They should write their names in gold today. Remember that any ill judgment they give today is going to affect them directly. Even the Bible said that the evil that men do live with them. This one is not going to live after them, because they still have their generation, they still have their children, they still have even their third generation and so on, of their relatives and all that. So if they fail to do the needful today, definitely karma is going to come knocking at their door. Definitely. Yes.
Some people are saying that Tinubu upheld by the Supreme Court as president. They are asking that as a question. He will not be upheld, because just like we did yesterday in our show, we said if the Court of Appeal does not do the right thing, they can still proceed to Supreme Court. So no shaking. We are certain that they will give us the right judgment today, and Nigeria will be saved today. Today is that day, and we are all eager and listening carefully and paying attention and looking into the court. At least we were able to have some of our people inside the court live and direct. So we are getting all our information right from the court.
And of course, don't say our PO talk say in gets hope for judiciary, in get faith for judiciary. So we equally will join our faith with his own and say we also have faith on the judiciary. We know that the judiciary, they're not going to fail us because they've done it before for him, and they will still do it again. So they're not going to fail this time. Judiciary should know that the power of the people stand. They should know that Nigeria is a democratic nation, and they should not give us otherwise. Yeah. Power belongs to the people. The rule of law has come to stand, and it must stand in our own case.
Yes, yes. So if any...
Make we even say as people they talk and for inside the comment section.
That's what. Okay.
You know, say as the thing they like, some people come they ask say why they know they bring, why they know they show the judge face. Well, anyway, when the thing is that when they do the court proceeding like that, when the person is reading from the court proceeding like that, they don't usually show the face of the a judge that is reading. I hope all of now when they ask for comment section, I hope say this one don't answer on our question now.
Okay.
And for why the man they stammer, anyways, no, it's up to him to answer. If he was not the one that actually wrote that something he was reading, or he was, I don't know why he was just fidgeting, or he was just anxious. I don't know, but all we know is that justice must stand. Enough is enough. We can no longer tolerate injustice in this country. A new Nigeria will pray for, and a new Nigeria we shall surely get.
Exactly.
Definitely.
Then our UC Maxwell posted and said that for months we gave you 1001 reasons to stay angry. A night to judgment, you want to move on. They are saying you should move on. You should not be this thing. And they say no. Come on, take back your country. This is our time to take back our country. We cannot move on anything. We have moved on long enough. We have moved on long enough. All these years that we have been suffering, Nigerians are in the habit of readjusting and getting used to situations. That is why we are blacks. We are the way we are. But now we have said no. We are tired of getting used to things. Fuel is above 600 naira. Above 600 naira. They are not doing anything to change it. And some of them are going out of the country. Some of them are just doing whatnot. And they're not even showing concern for the perils that the citizens of this country are going through.
Yeah, but Princess, come on. Where we even want to start to move on? Is it from the price of rice? Is it from the price of fuel? How much do they pay transport to come work every day? Calculate it. How much is remaining? If you remove your transport fare from your salary, how much is remaining? From where are we going to start to move on? Is it the electricity surge? Is it which parts? Will they move on anywhere?
We are not. We are here.
We must recover our mandates. We cannot move on. Power belongs to the people. The rule of law must definitely stand.
Yes, yes. So I don't know if our legal analyst is on Zoom now. You see Maxwell, so he can join us live. Yes. Good morning.
Yes, good morning to each and every one of you. It's a pleasure to join you guys on the conversation.
Okay.
So the thing is, from what we can see currently, they've struck out the case of the APM. They've struck out the case of the APM on two major reasons. Although the court held that the Supreme Court's judgment in the PDP versus INEC and Shetima, which was Exhibit X1 before the court, was final and substantial enough. Recall that the Supreme Court had held that the PDP had no local standing to question the nomination or double nomination of Shetima, and it went ahead to hold the view that there was actually no double nomination, even though a lot of people have criticized that judgment on the basis that the Supreme Court had no reason to go into the business of deciding whether there was double nomination or not, since it had already held that there was the existence of local stand. Another basis that the Justice Samani read in his judgment is the fact that for anybody to disqualify a candidate in an election, it has to be based on the provisions of Section 137 of the Constitution. And Section 137 of the Constitution provides that those are the disqualifying grounds. And the issue of double nomination is only in the Electoral Act. So for that reason, the court cannot disqualify anybody if it is not within the provisions of Section 137 or Section 131 of the Constitution. So as it stands, the court on this basis struck out the case of the APM.
Okay. So what is going on ground now? What's going on there now?
Well, as it is, outside the court, a lot of people are seriously protesting and rallies. They have the team who are pro-democracy. They have the team who are the Asari, the Kubo boys, which are camped somewhere else, also making some noise. And I am currently on ground here, about to even grant a TV interview, where a lot of Nigerians, well-meaning Nigerians, obedient, who are pro-democracy and supporting that the judiciary deliver justice in the case. So that is what is on ground. There is a lot of tension. There's a lot of security presence outside. Sorry, there's no tension, but a lot of security presence outside of the court.
Okay. I don't know. How long do you think it will take them before they come back to court?
Well, they told us 15 minutes, but we know the ages of these justices. But probably in the next 15 minutes or 20 minutes, we should have them back to court. So they've decided the APM's case and will move straight into the case of Peter Obi.
Okay. So who we are there? Like who were present in the court premises, like inside the court? Was PO there? Was Baba Atiku there?
From the information available to me, Peter Obi is not in court, but we have Shetima, the chief of staff, and some other APC members who are in court, but Peter Obi is not in court.
Okay. So who is representing Peter Obi?
I'm not so sure, but there are a lot of party members from the Labour Party and other bigger people from the Labour Party that are there.
Okay. So what are the expectations now for Labour Party's case? Because I think that's the next thing they should be handling when they come back to court, right? Hello?
Sorry, what did you say?
Yeah,
I said...
Maxwell, can you hear me?
I said that...
Maxwell, can you hear me?
Yes, I can hear you. What did you say?
Okay. Have they dispensed with the case of APM? And what case is coming later?
They have said from what it is, they've struck it out, but it is a consolidated case. So the judge on the petition, the case that is coming up later in the Peter Obi.
So what they have dispensed with is the double nomination.
Yes, for APM's case.
Any judgment that is not going to be disqualified.
Their consolidation. Are you sure they are going to talk about it again in the one of PDP or in the one of Labour Party?
They will still talk about it because it is also part of their case. They will still talk about it. So that is why they will give the final judgment later. Peter will be questioned double nomination. PDP questioned double nomination. So they are still going to talk about it.
We use this privilege.
Okay. Did they say any the one they are going to start when they come back from the break, like if it is PDP's own or the specific one they're going to deal with? Is Maxwell off?
I think so. I think they are back in session.
I said they will resume the case.
Okay. And who is making the noise at the background there? See if there is people who are shouting Tinubu there.
There are a lot of people who are speaking in favor of Peter Obi and for justice, asking for justice from the court. We are granting a TV interview currently, so I would need to get back to the conversation. I need to speak on the interview right now.
Okay, please, when you are done, come back so that you brief us more on what is happening on ground.
All right.
Okay, back to studio.
Okay. All right, thank you, Maxwell, for your short contribution. At least you have cleared the air now. The APM case has thrown out, or at least dropped, because of the case, the two bases they had. Yes. Hello. Yes, I can hear you.
Anyone that want to disrupt the information, please, and it's regarding to Tinubu issue, removing immediately. They don't want the betterment of that country. We are suffering here in England. We want to come and invest. Oh, please, we want good thing. We want good thing.
So I understand, sir.
If I can work, if I can work for 5 years, I have some million to come and deposit there. My people will benefit, and the economy will grow. So anyone that want to go against it, don't allow that person to talk, please.
Yes.
Okay, sir.
Okay, sir.
Okay.
Please.
Thank you very much.
We'll quickly go back to the live session in the court, because they are back in the court right now. So we'll quickly go back and yes, we'll come back later.
Okay, thank you. I'm watching. Okay.
Okay. Thank you. So let's go back.
Yeah.
In the court, they are back to the court now. So let's go back. All right. Yes, we are with you on that, sir. Okay. So everyone, we are going to go back to the court now. We just got information that they are back in session, and we'll come back after that to discuss. So
gold digging, contravention of the first schedule to the Electoral Act. In the above applications, all the respondents relied on the provisions of paragraph 4, sub 1, sub D, and sub 2 of the first schedule to the Electoral Act, and variously argued that the paragraphs of the petition which they have listed are liable to be struck out for being vague, generic, imprecise, and nebulous. So arguing they relied on several cases which are cited here. By contrast, the petitioners have submitted that the respondents' objection in the listed paragraphs of the petition are not vague, nebulous, sufficiently pleaded. On this point, the petitioners cited several cases which are reproduced here. Petitioners further argued that the facts in Belgore and Ahmed, and Ipiazu and Oti, Ogu and Ekwere Madu, Ojuku and Eradua, PDP and INEC and others, and Soga and Iguede, and all other cases cited by the respondents are not the same with the facts of this petition. Those documents were never pleaded by reference or incorporation in those cases. Additionally, petitioners have relied on paragraph 17.2 of the first schedule to the Electoral Act 2022 and argue that the respondents have joined issues with the petitioners on those paragraphs, having failed to seek for further particulars. They must be taken to I've carefully considered the submissions of the parties and the judicial authorities cited. It is right that adversarial civil litigation is basically fought on pleadings. It is the foundation of the parties' respective cases. General principle of law is that such pleadings must sufficiently and comprehensively set out material facts so as to ascertain with certainty and clarity the matters or issues in dispute between the parties. This is because the purpose of pleadings is to give adequate notice to the adversary of the case he is to meet and to afford him the opportunity to properly respond to such case. Its aim is to bring to the knowledge of the opposite side and the court all the essential facts, therefore a safeguard against element of Shodipo versus Lemini Kane, Odom and others versus PDP and others, Alassane and another versus Ishaku, citations given. The requirements of pleadings in election petitions are primarily provided in paragraph 4 of the first schedule to the Electoral Act 2020. Specifically, paragraph 4 sub 1 sub D mandates that, and I quote, an election petition shall be the Electoral Act 2020. Specifically, paragraph 4 sub 1 sub D mandates that, and I quote, an election petition shall state clearly the facts of the election petition and the ground or grounds on which the petition is based, relief sought by the petitioner, unquote. Subparagraph 2 of the same paragraph further provides that, and I quote, the election petition shall be divided into paragraphs, each of which shall be confined to a distinct issue or major facts of the election petition, and every paragraph shall be numbered consecutively, unquote. In addition to the provisions of paragraph 4 of the first schedule to the Electoral Act, paragraph 54 of the same schedule to the Act has made applicable to election petitions the rules of procedure in the Federal High Court of 2019, subject to such modifications as would bring same in conformity with the provisions of the Act. By Order 13, Rule 4 of the Federal High Court Civil Procedure Rules 2019, every party to an election petition shall ensure that amendments in their pleadings, and I quote, contain in a summary form the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved, and shall, when necessary, be divided into paragraphs and numbered consecutively. Quote. By subparagraph 4 of that rule, such facts contained in the pleading must, and I quote again, be alleged positively, precisely, and distinctly, and as briefly as is consistent with a clear statement. Quote. The aforementioned provisions contained in the first schedule to the Electoral Act 2022, as well as the Federal High Court's Rules 2019, state the mandatory requirements of pleadings in election petitions. The requirements for clarity and precision of fact required by paragraph 4 of the first schedule to the Electoral Act means that amendments must not be vague, ambiguous, or unclear, leaving room for speculation or conjecture, while the requirements of distinctiveness means that each amendment must contain a clearly understandable allegation, and there should be no confusion as to the linkages between facts contained in the amendments in the petition, and ascertaining the allegations being made in the petition. In particular, paragraph 4 sub 1 sub D, relating to the facts of the petition, the grounds on which it is based, and the relief sought by the petitioner have been severally considered and interpreted by the appellate court. In Belgore and Ahmed Supra, the complaint against the amendments in the petition was that they were unspecific, generic, speculative, vague, unreferable, omnibus, and general in terms. In that case, the Apex Court specifically held as follows, and I quote, pleadings in an action are the written statements of the parties wherein they set forth the summary of the material facts on which each relied in proof of his claim or his defense, as the case may be, and by means of which the real matters in controversy between the parties and to be adjudicated upon are clearly identified. Although only material facts are required to be pleaded in a summary form, they must nevertheless be sufficiently specific and comprehensive to elicit the necessary answers from the opponent. They must contain such details as to eliminate any element of surprise to the opposing party. In this case, where the dispute involves the election in as many as 895 polling units, the pleading in the petition, which allege electoral malpractices, non-compliance, and/or offenses in, quote, some polling units, many polling units, most polling units, or several polling units, cannot be said to have met the requirements of pleadings as stipulated in paragraph 4 sub 1 sub D of the first schedule to the Electoral Act and or Order 13, Rule 4 sub 1, 5, 6, and sub 1 of the Federal High Court Civil Procedure Rules 2009, unquote. Indeed, in PDP and INEC, the Apex Court was categorical when it held thus, and I quote, on whether the affected paragraphs were rightly struck out. I have read the affected paragraphs and found that they relate to allegations of non-voting in several polling units, disruption of election, non-conclusion of election, thumbprinting of ballot papers, falsification of election results, widespread disruption, irregularities, and malpractices without providing particulars or the polling units where the alleged malpractices took place. The lower court was therefore right when it held as follows. Above the paragraphs above, in my view, are too generic, vague, lacking in any particulars, and they are not tied specifically to any particular polling unit or any particular number of people who are alleged to be disenfranchised. The fact that a party can file further particulars or deny in a reply The averments in the pleading must not be general, must be specific as to facts. It is settled law that a petitioner's obligation to plead particulars of fraud or falsification without which the allegation is a non-starter. I have nothing to add to this statement of law as advanced above, and I adopt it as mine. Unquote. Indeed, on the provision of paragraph 17 sub 1 of the first schedule to the Electoral Act relating to further particulars, the Apex Court held in PDP versus INEC, Supra, that, and I quote, an application for an order for further particulars is merely a shield in the hand of a party who so desires, and not a sword to be used by a party whose pleading is grossly inadequate, insufficient, and devoid of necessary particulars as the appellant's petition was in the instant case. Unquote. A sober consideration of the decisions of the Supreme Court in relation to the requirements of pleadings in paragraph 4 sub 1 sub D of the first schedule to the Electoral Act 2022, on the one hand, and the decisions of the Supreme Court on the provision of paragraph 17 sub 1 and sub 2 of the first schedule the Electoral Act 2022 relating to further particulars on the other hand, shows that whilst in cases such as Abubakar versus Eraduan and Ombugadu versus Sule, the Supreme Court had held that a respondent who complains of vagueness of averments in an election petition should avail himself of the provision of paragraph 17 sub 1, first schedule to the Electoral Act, seek for further particulars or the direction of the tribunal or court. The decisions of the Apex Court, especially in PDP, INEC, Belgore and Ahmed, have specifically held that where averments in the petition are grossly imprecise and generic, such averments will be incompetent, liable to be struck out. See also on this EPRZU. It is therefore clear that the state of the law, as could be deduced from the various decisions of the Apex Court, is that the provision for further particulars, as stated in paragraph 17.1, first schedule to the Electoral Act 2022, will only come into play where the petition itself contains material or necessary particulars. In other words, paragraph 17 sub 1 of the first schedule to the Electoral Act 2022 does not bar a respondent from applying under paragraph 4 sub 7 of the first schedule to strike out averments in the petition which are grossly inadequate, insufficient, devoid of material or necessary particulars. This is because the operational words in paragraph 17 sub 1 is further particulars, and this means there must be some material particulars already pleaded in the petition before further particulars can be sought by the respondent. As born from the Apex Court decision in Belgore Ahmed, PDP, INEC, and EPRZU and OT, the law is clearly settled that specifying the particulars of polling units or places where irregularities are alleged to have occurred are material particulars in an election petition. Averments in an election petition which allege irregularities or malpractices but fail to specify the polling units or places where the irregularities or malpractices occurred are bereft of material particulars, and such averments are incompetent and liable to be struck out. As specifically stated in PDP and INEC, the petitioner who has failed to state such material particulars cannot invoke the provision relating to further particulars as a sword against the respondent in order to cure the incompetence of such averment. With respect, it is a misconceived argument on the part of the senior counsel for the petitioners to state that the latter decision of the Apex Court in Ombugadu and Sule Supra, which relates to further particulars under paragraph 17.1 of the first schedule, has departed the specific decisions of the Apex Court in Belgore Ahmed, PDP, INEC, EPRZU and OT, and several others on the mandatory requirements for stating material facts as provided in paragraph 4.1, first schedule to the Electoral Act. Contrary to the contention of the petitioners, the decision of the Supreme Court in Ombugadu and Sule Supra has merely reiterated the legal position relating to further particulars as provided in paragraph 17 sub 1, first schedule to the Electoral Act 2020. It has not departed from the above specific decisions of the Apex Court on the materiality of specifying in an election petition polling units or places where irregularities and malpractices are alleged to have occurred. Now, a look at the averments in the petitioner's petition shows that the petitioners have only alleged various irregularities and malpractices, but failed to specify the particular polling units or specific places where the alleged irregularities and malpractices have occurred. For instance, in paragraph 9 of the petition, where the petitioners avert that, and I quote, in appropriate cases, these agents raise complaints about anomalies where they occurred and reported such complaints to designated officers of the second respondent and the first respondent, unquote. The petitioners failed to specify the anomalies, the places where the anomalies occurred, the agents who complained, and the designated officers to of the second petitioner and the first respondent to whom the complaints were made. In paragraph 60 and 61 of the petition, while the petitioners allege that the first respondent, and I quote, suppressed the actual scores obtained by the petitioners by deliberately uploading blood from EC8As on the IRF in 18,088 polling units. The petitioners did not specify the polling units, but only stated that they will rely on spreadsheets containing the polling units codes and details of the 18,088 polling units, as well as the authentic results in the said polling units. In paragraph 66 and 67, where the petitioners allege that the first respondent embarked on, and I quote, massive misrepresentation and manipulation by uploading fictitious results in polling units where there were no elections, unquote. They did not specify the polling units where they allege there were no elections. Incorrect results that were uploaded and which are the correct results. Again, in paragraph 68 to 71, where the petitioners allege that the scores obtained by them were, and I quote, unlawfully reduced and added by the first respondent to the scores of the second respondent, unquote. They failed to state their scores that were reduced and added to that of the second respondent by the first respondent, and the figures that shows that the first petitioners won the election. In paragraph 72, 73, 76 to 78, where the petitioners allege overvoting, they merely stated that they will, and I quote, rely on the forensic reports of the election materials showing that the votes cast in the polling units in Ekiti State, Oyo State, Ondo State, Taraba State, Osun State, Kanu State, Yobe, and Niger States exceeded the number of votes accredited on the beavers in those states. Petitioners failed to specify the polling units in those states where the overvoting occurred, the number of votes affected, the margin of lead, which they claim that the voters who ought to legitimately vote in those polling units. In paragraph 73 of the petition, petitioners only stated that they will, and I quote, show that in the computation and declaration of the results of the election, based on the uploaded results, the votes recorded for the second respondent did not comply with the legitimate process of computation of the result and disfavored the petitioners, unquote. In Rivers, Lagos, Taraba, Benue, Adamawa, Imo, Bauchi, Borno, Kaduna, and Plateau, and other states of the Federation. Petitioners neither specified the uploaded results nor the votes illegally recorded by the second respondents and how they were disfavored. Paragraph 83 of the petition, where the petitioners claim that the first respondents scored the majority of lawful votes cast at the election, they did not state the majority of lawful votes they claim to have scored, especially as elections and the determination of who won is about figures. In paragraph 99 of the petition, where the petitioners say they will rely on from EC8As to establish that substantial votes were unlawfully credited to the second respondent, they failed to state the figures of the unlawful votes credited to the second respondent. In the petition, petitioners merely made generic allegations of various irregularities and malpractices against the respondents without specifying the polling units, collation centers, or specific places where the alleged irregularities and malpractices occurred. Rather, petitioners only stated that they will rely on spreadsheets, inspection reports, and forensic/expert analysis, which they say they have incorporated in the petition by reference. But none of the spreadsheets, inspection report, and forensic/expert analysis was attached and served along with the petition on the respondents. Rather, they were only listed as items 35 and 36 in the list of documents to be relied upon by the petitioners. It is only in paragraph 62 and 64 of the petition where the petitioners allege that the first respondents suppressed the lawful votes of the petitioners and inflated the votes of the second and fourth respondents in Rivers and Benue states. That the petitioners gave figures of the votes, where the petitioners gave figures of the votes suppressed for the petitioners and those inflated for the second and fourth respondents, and also stated that they claim to be the actual figures scored, what they claim to be the actual figures scored by them and by the second and fourth respondents. But all other paragraphs of the petition where irregularities and malpractices were alleged are bereft of any material details of the polling units or places where they were alleged to have taken place, or the figures of votes alleged to have been suppressed, inflated, or inflated. It is also pertinent to observe that in paragraph 79 of the petition, where the petitioners allege corrupt practices, they merely stated that they are repeating their pleadings in support of the grounds of non-compliance to be in support of their allegations of corrupt practices. It should be noted, however, that not every ground of non-compliance will amount to corrupt practice. In fact, the standard of proof of non-compliance differs from that of corrupt practices, while standard of proof of non-compliance is on the balance of probabilities, that of corrupt practices is beyond reasonable doubt. PDP, INEC, Mohammed Wamako, Code of Customs and Excise versus Alaji Ibrahim Barrow, citations on the record. It is instructive that in paragraphs 3.2, 3.21 of their submission, in opposition to the first respondent's objection, petitioners appear to have considered that in the averments of the petition, they have not specified the particular polling units where the alleged irregularities and malpractices occurred, or specify the figures of the votes or scores which they are alleged to have been suppressed, deflated, or inflated. Rather, they stated that the details of the polling units are contained in the spreadsheets and forensic analysis reports which they have incorporated and made part of the pleadings by reference. See particularly on this paragraph 67 of the petition. Petitioners further argued that since the respondents have failed to apply for further particulars under paragraph 17(1) and 2 of the first schedule to the Electoral Act, they are deemed to have understood those averments. However, by paragraph 15 of the first schedule to the Electoral Act 2022, when the petitioner claims, and I quote, that he had the highest number of valid votes cast at the election, the party defending the election or the return at the election shall set out clearly in his reply particulars of the votes, if any, which he objects to, and the reasons for his objection against such votes, showing how he intends to prove at the hearing that the petitioner is not entitled to succeed, unquote. This provision presupposes that the petitioner has a first duty to state clearly in his petition the particulars of such votes, in respect of which he claims to have scored the highest number of valid votes, and thus entitled to be returned as the winner. This also presupposes that it is only after the petitioner has supplied the particulars of the votes in support of his claim that he scored the highest number of valid votes that a respondent will then have a duty to object to any part of the particulars of such votes supplied by the petitioner in order to show that the petitioner is not entitled to succeed. With regard to the petitioner's contention that they have incorporated into the petition by reference the spreadsheets and forensic analysis report containing details of the polling units where they allege that the irregularities and malpractices occurred, it is right that for a document to be properly incorporated as part of pleadings by reference, the document must not only be referred to in the pleadings, but it must also be included as part of the pleadings to be served on the adverse party, so as to enable the adverse party to properly respond to same in his defense. Indeed, in all the cases of EFCC Rain, Ekpomo Polo versus Edere Moda, Marine Management Associates Incorporated versus NMA, and Dingyadi and Omako Supra, which were relied upon by the petitioners, the documents which were incorporated as part of the pleadings by reference were served along with the pleadings on the adverse party. In considering a similar scenario, this court by Ayola, JCA, as he then was, held in Nigeria Merchant Bank PLC versus Ayedun Investment Limited as follows, and I quote, "Before I part with this appeal, it is pertinent to advert to one pleading question raised in this pleading in regard to the consequence of a party pleading that he will rely on certain unspecified documents at the trial. The plaintiff contended that such averments made the contents of such document part of the pleading. In this case, the plaintiff in paragraph 30 of the statement of claim pleaded thus: the plaintiff at the trial will rely on all letters and documents between the parties pertaining to this suit. Although the principle is established that if an agreement in writing is referred to in a pleading, it becomes part of the pleading, and it is open to the court to give the agreement its true legal effect, irrespective of the term used in the pleading to indicate such effect. That proposition of law should not be used to cover such averment as shown above, which lacks specificity. Besides, a report such as Exhibit P22 in this case, prepared by a witness for the plaintiff and tendered at the trial by the witness, cannot be described as documents between the parties pertaining to the suit. At the appropriate time, when the occasion arises, the true ambit of the proposition of law in such case, such as Bank Genesis versus Petai Limited, ought to be defined," unquote. In the instant case, the spreadsheet and forensic report, which were documents prepared by the petitioner's witnesses, were not served along with the petition on the respondents, but were only listed as documents to be relied upon at trial. I'm not oblivious of the petitioner's argument in relation to paragraph 4, sub 5, sub C of the first schedule to the Electoral Act 2022, which provides that the election petition shall be accompanied by, quote, copies or list of every document to be relied on at the hearing of the petition, unquote. This provision undoubtedly only relates to front-loading of documents to be relied upon by the petitioner as his evidence during trial. Contrary to the petitioner's argument, it does not cover incorporation of documents into pleadings by reference. It is also noteworthy that the spreadsheets and forensic reports which the petitioners claim to be incorporating into the petition by reference are actually documents prepared by the petitioner's witnesses. In other words, the spreadsheets and forensic reports are not documents which are outside the control of the petitioners and which they have to obtain by subpoena. Being the petitioner's own documents, they ought to have served those documents along with the petition on the respondents, so as to enable the respondent to counter same by engaging their own experts to appropriately respond to same if they so desire. That indeed is the essence of pleadings, so as to avoid taking the other party by surprise. Petitioners have also tried to argue that the respondents, having joined issues on the general allegations contained in the petition, they are deemed to have understood same. With respect, this is also not a tenable argument in view of the grossly generic allegations made in the petition. Faced with a similar scenario, this court, Agungumiju JCA, as he then was, now JSC, held in Udiaga and another was Omegara, as follows, and I quote, the argument of appellant's counsel that the respondents did not adequately traverse the petition is unfounded. The petition itself contained general complaints. There was no effort to pinpoint in the pleadings the various places where corrupt practices, non-voting, use of violence, forgery, rigging in polling units, passive thumbprint of ballot papers, fictitious entry of election results took place. Therefore, there was a general corresponding reply denying the allegations in general terms from the respondents. If the petitioners did not plead particulars, how could the respondents traverse non-existent particulars? The arguments in the appellant's pleadings should have contained details of the allegations and complaints which the respondents could reply in detail in their own pleadings. Appellants expected the respondents to reply to the various specific allegations contained in the witness statements filed along with the petition. That is not the correct procedure. Those specific allegations should have been in the pleadings. The pleadings must show the facts disputed, while the witnesses would give evidence of these facts. In election petitions, it has been held that there is the need for particulars where required in order to prevent taking adverse party by surprise. It is not the function of particulars to take the place of necessary arguments in pleadings, unquote. Indeed, in a presidential election like the one being challenged in this petition, where it was held in 176,846 polling units, 8,809 wards, 774 local government areas, 36 states and the Federal Capital Territory, it is unimaginable that arguments in the petition which merely allege irregularities and or malpractice without specifying the particular polling units or particular collation centers where the irregularities or malpractices have taken place will be regarded as proper, merely because the respondent has not requested for further particulars. Tibel Goria Ahmed and PDP. More so, when an election petition is by nature a declaratory action, in which the petitioner succeeds only on the strength of his own case and not on the weakness of that of the respondent. Ibusari versus Adepoju, Oyetola versus Adeleke, and Anazong versus Onubogu, citations on the record. It is in this respect that a petitioner has an obligation to set up a clear, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of a party's case, and it is to the pleadings that the parties to litigation, as well as the court, are all bound. See Enang and others versus Adu. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units, collation centers, or the specific places where the irregularities and malpractices are alleged to have occurred, or the figures of votes which are being claimed are grossly vague, imprecise, nebulous, and bereft of material particulars, and have thus failed to meet the requirements of paragraph 4, sub 1, sub D of the Electoral Act 2022. In accordance with paragraph 4, sub 7 of the said schedule, the said paragraphs are consequently hereby struck out. On the first respondent's prayer to strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition, the essential contention of the first respondent is that whilst in paragraph 57 and 58 of the petitioners have alleged that the first respondent failed to comply with the order of inspection granted by the court, petitioners have in paragraphs 65, 67, 70, and 71 stated that they will rely on the report of the inspection. Additionally, the first respondent also argued that the first petitioners have alleged that the election was marred by corrupt practices and was not conducted in substantial compliance with the Electoral Act 2022. They have also alleged that they have scored majority of lawful votes cast and should be declared the winner. Relying on some cases which are produced here, the first respondent urged the court to strike out the paragraphs as well as prayers 1 to 4 on the one hand, and prayers 5, sub 1, and sub 2 on the other hand, for being inconsistent. Conversely, the petitioners contend that the law allows them to plead conflicting facts insofar as they have claimed alternative reliefs. They referred to the alternative reliefs at pages 35 to 37 of the petition, relied on some cases which are reproduced here, as well as the ruling on similar objection by the 2019 Presidential Election Court in the previous case. As rightly submitted by the petitioners, the reliefs in this petition, which I have reproduced at the beginning of this ruling, are undoubtedly sought in the alternative. The settled law is that reliefs can be sought in the alternative, and where so sought by a party is at liberty to plead conflicting facts in line with the alternative reliefs he has sought. In Adigije versus Nwaugu and others, this court, Ogunwumiju Jesse, as he then was, held that, and I quote, in civil litigation and indeed in election matters, a party can make two seemingly contradictory pleadings, leading to two different heads of claim. That is why a petitioner can claim that the election be annulled for reason of substantial non-compliance and in the same breath claim that he won the election by a majority of lawful votes. Petitioner may plead the same set of facts to ground alternative reliefs. Those pleadings are not ipso facto held to be self-contradictory. The court can only grant one relief as the party must decide which relief is best supported by the evidence on record. Unquote. See also on this Metal Construction West Africa Limited versus Abodering, citation given. In any case, the first respondent, which is the body that conducted the election and to whom the first petitioner's nomination documents were submitted by the second petitioner, admitted in paragraph 4 of the petition, wherein petitioners averred that the first petitioner was duly sponsored by the second petitioner, on whose platform the first petitioner contested it. I therefore have no hesitation in discountenancing this ground of the. Now, second category of objections or applications. These are the categories that challenge the competence of the petition on some of its grounds. The second category of the respondents' applications that challenge some of the grounds of the petition and or the competence of the petition are as follows. First, respondents' motion filed on the 19th of April 2023, seeking 1. Order striking out ground 2, paragraphs 33 to 79, and reliefs 5, Roman 1 and 2 of the petition on transmission of election results for being cut off by issue estoppel. 2. Order striking out paragraphs 20, Roman 1, 21, 23, 24, 25, 26, and 27 on nomination of the second and third respondents for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023, seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2, and 3 of the petition. 3. Order striking out reliefs 1, Roman 1 to 3, 2, 3, 4, Roman 1 to 4, 5, Roman 1 and 2 of the petition. The above two motions are predicated on several grounds, which are reproduced herein. It is the view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2, relating to the allegations of corrupt practices and non-compliance of the Electoral Act 2022, and the plea of estoppel in relation thereto, as well as the issue relating to competence of the reliefs sought in this petition, are matters on which the parties have joined issues in the main petition, the merits of which will be decided after considering the pleadings and evidence laid in the petition. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in substantive case. Wanko and others versus Eradua. Ocholi on Onojo James, SAN versus INEC, citations on the record. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's locus standi, the non-joinder of necessary parties, and the objection to the competence of the petitioner's replies, the respondent's replies, or some paragraphs of the petitioner's replies. Lack of locus standi of the first petitioner. The second and third respondents and the fourth respondents in this motion their motion filed on the 8th of May 2023 also objected to the first petitioner's locus standi to bring this petition. The principal contention is that the first petitioner was in contravention of section 77 sub 3 of the Electoral Act 2022. They argue that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership of that party on the 24th of May 2022, joined the second petitioner on the 27th of May 2022. They contended that as at 30th of April 2022, the first petitioner could not have been in the register of members of the second petitioner, which it submitted to the first respondent 30 days before the presidential primary election, as mandated by section 77 sub 3 of the Electoral Act 2020. And since the first petitioner is not in the membership register submitted by the first respondent to the first respondent by the second petitioner, the first petitioner lacks the locus standi to challenge the outcome of the presidential election. By contrast, the petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned, and the court lacks the jurisdiction to entertain it. They relied on the cases that are reproduced here. The courts have consistently held in a plethora of cases that the issue of membership of a political party is an internal affair of the political party. It is not a justiciable issue, and courts have no jurisdiction to entertain it. See Enang versus Asukwo, others, Sani and Galadima, and Tumbido versus INEC, citations on the record, as well as all the cases cited above by the petitioner. The provision of section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its party primaries, cannot be invoked by the respondents for the purpose of challenging the first petitioner's membership of the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as its candidate for the presidential election, the first petitioner has satisfied the requirement of being a member of the second petitioner as provided for in section 131 sub C of the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent to question the first petitioner's membership of the second petitioner. This ground of objection is hereby overruled. No enjoinder of necessary parties. The first respondent in his motion of 19th of April 2023 and the second and third respondents, as well as the fourth respondent, raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 of the petition, the petitioners who came third in the presidential election are seeking to be declared the winners of the election. The petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election, as respondents to the petition. For that reason, the respondents have contended that this court lacks the jurisdiction to entertain the petition as constituted. Place reliance on JJD and INEC. Buhari and Obasanjo, citations on the record. No position, however, petitioners relied on the cases of Obasanjo and Eradua, Buhari and Yusuf, Akpoti and INEC, and contended that only statutory respondents provided in section 133 of the Electoral Act 2022 are necessary parties to the petition. The petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic Party. By Section 133 of the Electoral Act 2022, the statutory respondents in an election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which will also be deemed to be defending the petition on behalf of its officers whose conduct is complained of. In the cases of Obasanjo and Eradu and Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties to an election petition. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate 2 or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of Jegede and INEC cited by the first respondent is clearly not applicable to this case, since the decision in that case is that Maimala Buni was a necessary party because by the provisions of Section 183 of the 1999 Constitution, would have ceased being a governor of Yobe State if the case made out in the petition that you could not combine the offices of governor of Yobe State and acting chairman of the All Progressive Congress is sustained. In this case, Abubakar Atiku, the People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties, as they are not statutory respondents to this petition, and the petitioners herein have no obligation to join them in this petition. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself a respondent to his petition. Also, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition number CAPEPC 05-2023, which, as mentioned in the earlier part of this ruling, this court has consolidated with the petition signed with paragraph 50 of the first schedule to the Electoral Act 2022. This ground of objection to the competence of the petition is unmeritorious, is accordingly overruled. On the arguments over the competence of the relief sought in this petition, it is my view that the reliefs which the court can grant in an election petition are statutory, as provided in Section 136, sub 1, sub 2, sub 3 of the Electoral Act 2022. Therefore, the determination of whether the relief sought by a petitioner are grantable can only be made after trial. Challenge to competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are first respondent's motion filed on the 9th of May 2023 seeking 1. Order striking out the petitioner's reply, the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraphs 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41 of the petitioner's reply for offending the provisions of the first schedule to the Electoral Act 2020. Second and third respondents' motion filed on the 13th of May 2023 seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. Fourth respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply, the fourth respondent's reply, as well as the witness statement on oath with failure to deny the fourth respondent's allegation. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26, Roman 1 and 2, 27 to 31 of the petitioner's reply, the fourth respondent's reply for raising new issues. All the respondents challenge the competence of the petitioner's reply, their respective replies, or in the alternative, the paragraph thereof, which they have variously listed above. Their essential contention is that the replies, or in the alternative, the paragraph thereof, have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or a mere repetition or a hash of the facts contained in the petition, contrary to the provisions of Section 16, Paragraph 16, Sub 1, A and B of the first schedule to the Electoral Act 22. Respondents replied on several judicial authorities, which are reproduced. In response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification of the second and third respondents, as well as the non-compliance by the first respondent with the Electoral Act 2022. They relied on Silva and INEC, PDP versus Ezeonguka, citations on the record, and urged the court to discountenance the objections of the respondents and uphold the petitioner's reply. Now, paragraph 16, sub 1A of the first schedule to the Electoral Act 2022 provides as follows, and I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, the petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, the petitioner's reply in answer to the new issues of fact. So, however, that A, the petitioner shall not at this stage be entitled to bring in new facts, grounds, or prayers tending to amend or add to the contents of the petition filed by him, unquote. By the import of paragraph 16 sub 1A of the first schedule, petitioner may, in filing a reply, respond to allegations of new facts raised in a respondent's reply to the petition, provided he does not, in so doing, amend or add to the petition. It is instructive to observe that the words used in paragraph 16 1A are, quote, new facts, grounds, or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision envisages, therefore, is that the reply of a petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt to amend or add to the petition. See All Progressive Congress versus People's Democratic Party, Njadi and Wamako, Adepoju versus Awoduyi Lemi, and Ikoro versus Izunaso, citations on the record. Indeed, in succinctly explaining the new issue which should attract the reply, the Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote, a new issue to attract a reply must in law be really new in the sense of being brand and fresh. The issue must be really new to the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time in the statement of defense by the defendant. The new issue, in both its contents and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issues with the plaintiff, and that does not bear the name of a new issue in law. A new issue arises where the plaintiff did not avert to or touch the contents of the defendant's averments in anticipation. The defendant's averment was introduced pleadings for the first time and therefore unique and novel to his pleading, unquote. A careful examination of the petitioner's petition, the first, second, and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, petitioners also introduced new facts in their replies, the respondents' replies, which were not contained in their petition. This is in clear contravention of paragraph 16 sub 1A of the first schedule to the Electoral Act 20. Paragraph 16, 1 to the law as encapsulated in paragraph 16, 1A of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in the petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental right to fair hearing, guaranteed by Section 36(5) of the Constitution of the Federal Republic of Nigeria, 1999, since the respondents will have no opportunity to respond to those new issues, additions, or amendments. See PDP and another versus INEC, others. Maku and another versus Al Makura and other citations on the record. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 of the first respondent's reply shows that the paragraphs has not raised any new issue contrary to the assertion of the petitioners. In paragraph 15 of their reply, the first respondent's reply to the petition, it's only a response to paragraph 7 and 8 of the petition. But the petitioner's argument in the same paragraph 15 that the first respondents' officials at the polling units failed to give clear copies of the results of the election from ECHA to the petitioner's agents, as the pink copies given by the petitioner's agents were very faint and unreliable, is a new fact which tends to amend the petition. Paragraph 16, Roman 1, 7, 17, second part of 18, 22, 24 of the first respondent's reply are traverse of paragraphs 21 to 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purport to respond to new issues in paragraphs 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment of the petition. Also, paragraphs 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, and 37 of the petitioner's reply, the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply, the petition, the latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation against the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. The said paragraph 21 of the petitioner's reply to the second and third respondent's reply is hereby struck. Similarly, petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations the fourth respondents, which the fourth respondent has no opportunity. In contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also hereby struck. And that indeed is the rulings on the respondents' objections, various objections.
Well, as I was trying to explain earlier before we went for the break,